Okay, hello everyone. Good evening and welcome to this webinar entitled The Longest Path versus Negative Flow Theory, the debate, a DAAB case, dispute avoidance and adjudication case. And speakers are Dr. Tariq Hamid, who plays the role of the sole dispute adjudication and avoidance engineer Hussam Andil, who plays the role of the engineer, engineer Ahmed Afifi, who plays the role of the employer, and myself, who plays the role of the contractor. Now, just by means of introduction, Dr. Tariq Hamid has over 30 years of experience in construction contracts, claims, and dispute resolution. And he has a PhD from Cairo University, diploma in international commercial arbitration from Cairo University in 2001, a BSc, MSc in Cairo University, and he is managing director of DAAB for engineering contracts from 2014 until present. Mr. Hussam Andil has over 18 years of experience in construction project controls and forensic analysis and risk management. He has a BSc in civil engineering from Ain Shams University in 2002. As you see from his certifications, he has a lot of certifications in risk management and project controls. He's also currently the project manager at NBK, the National Bank of Kuwait, Egypt branch. Mr. Afifi has over 15 years of experience of construction and industrial project management. He has an LLM in construction law and arbitration from the Robert Gordon University, an MSc in construction project management. He is a committee member at the Chartered Institute for Arbitrators, Egypt branch, and he has experience in 8 countries in Africa and the MENA region. My name is Walid. I have over 20 years of experience in construction contracts and claims. I have a PhD from the University of Salford, 2017, from Robert Gordon University in 2009. My bachelor's and master's degrees in construction engineering were from the American University in Cairo. And I'm currently vice chairman of the CIR Egypt and vice chairman of AACE Egypt, and the country rep for DRBF recently. This is from 2020 to present. I also have served in alternative dispute resolution as an expert adjudicator and arbitrator. And I'm also currently an adjunct assistant professor at the American University in Cairo in the construction engineering department. Now, this event is a AACE/DRBF event. So I'll just provide a brief introduction to both. As you can see from my introduction, I sort of, I'm wearing both hats. So I'm a member in both, and this is a joint event. So we'll start first with AACE. The AACE stands for the Association for the Advancement of Cost Engineering International. This is a screenshot from the website. And basically, it's a US-based nonprofit professional association that has been serving the total cost management in community since 1956. And by total cost management community, we mean various disciplines such as cost engineering, cost estimating, planning, and scheduling, decision, and risk management and project management. Now, there's over 8,000 members worldwide, and there's also AACE is divided into several sections all over the world. So we have they cover 100 countries and cover 90 local sections. They have been certifying individuals since 1976, and this certification is probably one of the things that AACE is well known for. So you have several certifications such as the Certified Cost Professional, the CCP, the what is also for those who are interested in dispute resolution, there's the Certified Forensic Claims Consultant, the CFCC, there's the Earned Value Professional, Another famous one is the Planning and Scheduling Professional, the PSP. And in Egypt, we are one of the 90 local sections of AACE International, and we're a very, very small section. We're just a 24 member. Our aim is to become one of the leading sections for AACE International worldwide. We believe we are fit for that, and we are up for the competition. Now for the Dispute Solution Board Foundation, this is the screenshot from their website. It is basically, this is the website link. It's a nonprofit organization that was formed in 1996 to promote the use of dispute boards worldwide. It has over 1,000 members from 70 countries, and its objectives are, as you can see, these are the published objectives for DRBF, including increasing the awareness and use of dispute boards, whether they are dispute review boards or dispute adjudication boards, but this is the most important objective. Of course, educating the industry and providing training workshops. There's also the dispute board manual that has been published in the DRBF, and there's newsletters and providing networking for members. Again, also for Egypt, the Egypt members for DRBF are actually very, very, very little. Last time I counted, we were only 4. So by this event, really, we're hoping that we can have a lot of members for AACE and for the DRBF, and we encourage, we invite those also who are in Egypt to please join both, because we have a lot that we want to achieve, and with your help, we can do that. And this is also one of the latest manual for the DRBF, the 2019 Dispute Board Manual, and it has a lot of best practices for dispute boards, and it's available at the DRBF website for free. And you can just go to the website and you can download this manual. This would be the second edition. There was a manual, I believe it was in 2007, and this is the second updated edition for the DRBF. Now, we'll go to the essence of the presentation. This presentation, this webinar, really is
ask the audience to
yes.
Mute their microphones.
Yeah, I believe there's an option where I can mute all.
I guess I'm hearing someone.
I don't seem to find it. Yeah, I know. I'm. Let me check. Okay, so as a background to the disputes, we have a, first of all, this is the construction, the project involves the construction of a new alternative dispute resolution center in Cairo, Egypt. As we all know, we have the main arbitration center in Egypt is the CRCICA, the Cairo Regional Center for International and Commercial Arbitration. So here we're assuming that we are constructing a major ADR center in Cairo, Egypt, the headquarters of that center. And the commencement date for the project was 15th of June, 2018. And the contract completion date was the 1st of July, 2020. The progress percentage as of this month was 93%. So by that, the contract completion date has lapsed now by several months. And from the time that the contract completion date has lapsed until this moment, there has been a series of variations or change orders that have been issued to the contract. And basically, the employer has finally applied liquidated damages on the contractor, and the contractor invokes the dispute adjudication and avoidance board procedures. And as you probably have guessed from the name DAAB, the contract that this project is using is the FIDIC Red Book 2017 edition. So just as a housekeeping for questions and answers, please insert your questions in the chat box, as you can see here from the screen. And what we'll do at the end of the webinar, we will try to answer your questions in chronological order. So we will go with with the one that has been sent first, and then second, and so forth, until we conclude with the time allocated for this webinar. Now, before going further, I would like to first launch a poll. And first, the question is, you can see here on the screen, there are 3 questions. Just as an introduction, the first one is, what party in a construction contract are you currently associated with? Are you a contractor, employer, engineer, or none of the above? And second is, did you hear of the longest path theory before? Third is, have you encountered a situation where a contractor is in delay and is issued variations after the completion dates? Now, I'll just give you a few, like a minute, if you can please, if you can all participate. Thank you. Okay, so we have still 80%, 33 of the 41 present so far who have voted. If we can get more votes, we'll share the results. Okay, so as you can see, we have on the screen 39% who are contractors, and employer is just 8%. And then the engineer is also, so the contractor mostly is contractors and then engineers. Did you hear of the longest path theory before? 56% answered yes. And it seems that almost half have answered that they've encountered the situation with the completion dates. Okay, so with that, we will start our presentation, and the floor is yours, Dr. Tariq. I'll just stop sharing the screen and you can share yours.
Dr. Tariq, your mic is muted.
Dr. Tariq, you are muted.
I welcome you all. First, I want to confirm the attendees. Here's Mr. Walid Nam for the contractor. Yes?
That's correct. Dr. Tariq.
Yes, welcome, Mr. Namr. And we have Mr. Ahmed Afifi
Thank you.
for the employer.
Yes, that's correct.
Yes. And we have Mr. Hussam Andil for the engineer.
Yes.
Yes, welcome
I'm
all.
here.
In this hearing, I just want, before we start, just to confirm that your contract is a FedEx contract 2017, and you had the chance to have a standing DAAB committee. However, this was not the case. You can benefit from this in future projects. However, we will start this session as an ad hoc DAAB. As you all, both parties know, the decision rendered by the DAAB has a binding effect in both parties. So, subject to the other provisions of the contract, whenever the decision is issued, both parties has to abide by such decision. Before I let you start your presentation, some housekeeping points. First, I've sent you the DAAB agreement, and I expect receiving the signed copies of this agreement at the soonest. So do you confirm that you will send this, Mr. Walid, Mr. Hafifi?
Today after the meeting, after the hearing.
Yes.
Thank you. The second point of housekeeping is regarding if both parties wish this session to be recorded and to have a manuscript for this.
Excuse me, what type of recording are you talking about, sir?
Video recording or sound recording, if you wish. And
Is this a mandatory thing?
I don't mind. I don't mind recording, Dr. Tariq.
Okay.
Well, I have a conservation related to the video recording. However, we can just compromise the audio recording.
Okay, if so, both parties agree for audio recording. Okay. Confirmed?
Yeah, I prefer video, but if the employer wants audio, خلاص.
Restrict to the audio recording. Okay.
Okay. Audio recording. Okay. Yes. Okay. I confirm receiving the notice of dispute by the contractor, in which both parties, in which the contractor stated what is exactly the dispute, and also the employer confirmed the statement of dispute. I confirm also receiving the position papers from both parties, the contractor and the employer. So I am expecting the presentation today to be reflecting the main points that have been raised in these position papers by the contractor and the employer. If you allow me also, I want to make reference to DRBF 2019 manual regarding some rules regarding the hearing. First, the DB hearing is not a judicial process. Accordingly, oaths are not administered in such sessions, hearing sessions. In addition, legal rules of evidence are not observed. And most importantly, except at discretion of the dispute boards, cross-examination of witnesses is not permitted, and direct party-to-party questioning is not permitted. Is that clear for both parties?
Yes.
Clear, Dr. Tariq. It's clear, yes.
So regarding the procedure now, I'll let the contractor provide his presentation, maximum 20 minutes for the presentation. Then the employer will provide his presentation, then also maximum 20 minutes. After that, questions by DAAB will be addressed to both parties. And then we will conclude and say what are the next step by DAAB. So I'll let you, Mr. Namr, to start the presentation for the contract. Please go ahead.
Okay, thank you. Just give me a second to share my screen, Dr. Tariq.
Sure.
يعني لو موجودين كده هم سامعين. تصدق انا بدات اسمع خجوشه بس عارف اللي هو تحس النت ضايع. انت عملت ايه بقى؟ هو سامع؟
Okay, do you see the screen, Dr. Tariq?
Yes, please go ahead, Mr.
Okay,
Lim,
so okay,
Yes.
thank you.
The presentation is clear. Go ahead.
Okay, thank you. First, I'll start with an outline of my presentation. And طبعا, of course, this outline, this is really is a summary of what I had written in my written submissions prior to this hearing, Dr. The first one is that the longest path completion date is not really is not contractual at all, and that's the first point that I want to mention. The second is that I want to highlight the employer's complete disregard of my monthly report qualifications. And third, the employer and engineer's breach of good faith. And I'll conclude with the recent USA literature and case law. If you'll give me a second, Dr. Tariq, because I think I hear some sounds and I'm going to try to mute them.
Yes.
Okay. Okay, so first of all, with the longest path not being contractual. So my understanding of the employer's application of longest path theory is as follows, Dr. Tariq. So I'm going to try just, if you can bear with me, and I will try to explain my understanding of how the employer applied the longest path theory so that liquidated damages are applied on the contractor. First of all, we had the commencement date of the project, and then we had the contractual duration for implementing the works, and that's the contract completion date. So this is what we have here is what we have agreed upon as contracting parties. So after that, the duration was prolonged after the contract completion dates, and there was a forecast completion date that was forecast in my monthly reports as a contractor. And basically, there were variations. As you can see here, CVI 35. CVI stands for Contract Variation Instructions. So I was given instructions for variations by the engineer and that were approved by the employer. I was given that, as you can see, from before just prior to the contract completion date, but after it as well, the duration of this variation. And then I got CVI 36 shortly thereafter, and CVI 37 shortly also after. However, I have to acknowledge, Dr. Tariq, that the delay was predominantly mine. I had some problems with resources and with some cash flow issues in light of the current circumstances of COVID-19 and so on and so forth. I acknowledge that. I don't deny that. However, there are variations that have been issued throughout also my delay. And by the employer's understanding of the longest path theory is that this is the longest path leading to completion, which is my path, and therefore all these employer delays are non-critical. So the essence of the dispute, Dr. Tariq, is that I'm saying that the main reference for the contract completion and whether and the critical path of the project is this contract completion date, which was agreed between the parties, and everything after that contract completion date is critical, including these variations. Now, what the employer is saying with through the engineer is that with the longest path is because this is the longest path to completion. Therefore, anything in the midst of this path, including these variations, including any other employer delays, are simply non-critical, and therefore the employer is entitled to apply liquidated damages on the full duration from the contract completion date till the forecast, as if no variations were instructed, as if there were no employer delays, and that is the longest path theory, and that is something that I completely reject, Dr. Tariq, and that's the essence of our dispute today. So let me illustrate from a contractual standpoint by quoting some FIDIC 2017 clauses, Dr. Tariq. First of all, clause 1.1.28, delay damages. Simply, it's the damages for which the contractor shall be liable under clause 8.8 for failure to comply with subclause 8.2. And I highlight here, Dr. Tariq, failure to comply with subclause 8.2. 8.2 has the agreed upon contract completion date that is in the contract. And that completion date is the essence or is the basis from which liquidated damages would be applied, not any other date. And so the time for completion, that is this contractual time for completion, according to 1.1.84, means the time for completing the works or section as stated in the contract data as may be extended under subclause 8.5, which deals with the extensions of time. Again, I highlight which may be extended. So therefore, we have a contractual completion date, and this contractual completion date may be extended through the mechanism in the contract. And it's this basis which would have to apply the liquidated damages on, Dr. Tariq. So this is a very important distinction. And the main distinction is that there is no reference at all in the contract to the so-called longest path as the basis for EOT after the lapse of time for completion. There is no reference to this so-called longest path as the basis for to give the employer a green light to just apply damages and to consider all his delays after the contract completion date to be again I have to just mute Dr. Tariq, so
Please.
okay, I'll resume my presentation. So there is no reference, Dr. Tariq, to this longest path in the contract. This is something that is alien to the contract. And now the employer and his engineer are just discrediting all their variations because of this new so-called thing called the longest path. Now, my second point is the monthly report. Now, what's the significance of the monthly progress reports, Dr. Tariq? The significance is that in the monthly progress reports, I was submitting, of course, it has the forecast completion dates as forecast each month. So the employer has really, or his engineer actually has used these forecast longest path, the forecast, and of course, and I have to highlight, Dr. Tariq, maybe this is something I did not highlight from the beginning of the presentation. I am not discrediting the principle of the longest path. Longest path is important because I'm using it, I was applying it in my monthly reports because we have to know in the project, as in all construction projects, we need to know when the project is going to finish. So there has to be, we have to look at the longest chain of activities so that we can forecast when the project is going to finish. So my main problem, Dr. Tariq, as I mentioned in my submissions prior to this hearing, is that when this forecast date is used as a basis for application of LDs liquidated damages, and for the basis of discrediting all employer delays that happened before that non-contractual date. So now back to my point. The engineer has relied on my longest path date from the monthly reports, which was, of course, a natural, normal course of business. And then, but he completely disregarded the qualifications in the monthly report. I had a lot of qualifications. So if we're going to take consideration of my monthly reports, then we have to take consideration of it as a whole. And in this coming slide, I will just, of course, you have the details in my submissions, Dr. Tariq, but then let me just go through very briefly the sections of my report where I listed the qualifications. So for example, table 5 in my monthly reports was entitled employer variations, and I had all the employers variations that I've encountered throughout executing the work. And I listed them, and I had a reservation, a note that I'm reserving my rights to an extension of time. And bear in mind that the 3 CVIs that I have highlighted in the beginning of my presentation, I have not received any extensions of time for those at all. Section 3 in the report, I listed the risks and concerns, and I also included extension of time reservation notes. This is in several monthly reports, by the way. And also section 6 claims, I also listed the claims, and I had my reservations rights notes. And in section 8 conclusion, I also had concluded with the reservation of rights for an extension of time, and I received nothing, no acknowledgement whatsoever from the employer or his engineer.
Excuse me, are you considering the monthly reports like a notice, the contractual notice? Did you ever exercise the notice period is in the contract?
Didn't I submit it to you?
Ahmed, we will address this in my reply. Just let him continue whatever he's saying now, and we will address this later. Just calm down, please.
Mr. Afifi and both parties, I just draw your attention to what we have stated in the beginning, that direct party-to-party questioning is not permitted. So please abide by such rules to have a conductive hearing session, please.
Dr. Tariq, this is really بصراحة, it's very discouraging that I'm interrupted in the middle of my presentation. So this is something that can I go on? Can I resume my presentation, please?
Yes, please resume.
Okay, thank you. مش ممكن يعني. Okay, so the third point that I want to mention, Dr. Tariq, is this issue. So why am I stressing this issue of good faith? You know that in the Egyptian law, there's Article 148, which mandates that contracts be performed by good faith. So it's not just a nebulous, vague concept. This is mandatory by the Egyptian Civil Code, which governs this contract. And what happened in this project, Dr. Tariq, is completely contrary to good faith. So what happened is that, as I mentioned, I had 3 CVIs that were issued for executing variations after the contract completion dates. And in good faith, I have actually received those instructions. I have executed the work and had no idea whatsoever of the intentions that the employer had of applying damages. And actually, what I'd like you to know that we have in the project, we have this form, which is issued after variation is completed. And this form is a change order form. We call it a CVO form, a contract variation order form. And that form has it has a tracking of the pricing of the contract and the time of the contract. So we know that with each variation or each change order, what is the contract price now, the updated contract price, and the time as well. So normally throughout the project, we would negotiate the cost of these changes and the time, and we would of course bear in mind I had received no time extensions at all, but we would negotiate the prices, and then I'd get this form and we sign it.
Are you simply asking us to do your job? You are asking us to do your job here.
Am I interrupted again here, or what? Am I interrupted again?
Because I could not help.
Mr. Andil, please, you are both reminded of the rules of this session. Direct to direct questioning is not permitted. Please do not interrupt again, Mr.
Okay.
Ali. Please.
I'm sorry, I acknowledge this, but I could not resist. But I'm sorry,
Okay.
I'm not going to do this again. Sorry.
Please go ahead, Mr. Ali.
Actually, my patience is running thin. Actually, it's just this is unbelievable.
Me too.
I'll just share my screen for the second time. So what happened, Dr. Tariq, is that the 3 variation instructions that have been issued, none of them did I receive this form that I'm used to receiving throughout the contract. And that has led me to believe that liquidated damages would not be applied because had I known that the revised completion date would not be, there would not be an extension or if I had known the intentions of the employer, maybe that would have made me react differently to the variations that were issued to me. So in essence, the engineer kept silent regarding his intention to apply delay damages. And that, Dr. Tariq, is contrary to the principle of good faith. Now, I completely reject this action and I consider this contrary to the good faith principle. And I have to highlight something here, is that Clause 8.8, the delay damages clause, has a time bar on the employer that if the employer intends to apply liquidated damages, then I must receive the notice within 28 days for applying the liquidated damages. You cannot just wait till the end of the project until I finish all the variations, gave the employer all that he wants, and then the employer decides to conveniently apply liquidated damages, Dr. Tariq. So this is in complete violation, not only to the principle of good faith, but to our contract as well, clause 8.8. And let me also remind the employer and his engineer of something very important. And one of the reasons why I would presume why this FIDIC 2017 contract was chosen, and that's in clause 3.7 agreement or determination, the engineer has a duty to act neutrally and not to act on behalf of the employer when making determinations. And that includes, Dr. Tariq, when there are variations that are issued and a determination needs to be made as to their impact, then the engineer should act neutrally and not be biased for the employer. And also I have to mention here that 3.7.2, the engineer's determination, the engineer is required to make a fair determination. So he's sort of acting like a judge, he's neutral, and by all means, the engineer has definitely breached this contractual obligation.
Sam, excuse me, what is the contractor saying about neutral and fair and fair determination about acting neutrally between the parties? This is not our consultancy agreement, by the way.
Yeah. I will explain to you later. Okay.
Please.
We're sorry, Dr. Tariq.
Continue, Mr. Reid.
Sorry, Dr. Tariq. Just side discussion.
Okay, here I go again. The fourth point I want to mention is really about recent USA literature and case law, and this is actually important, Dr. Tariq, when it comes to the longest path theory. Now, in the contractor's submissions, he always mentions that the longest path theory is something that the SCL, the Society of Construction Law, uses, that AACE uses this, and the other he also quoted other articles from prominent authors worldwide and cases as well. However, I have to say that the tide is turning against the longest path. And actually, if we look at this important reference, this USA book, Construction Scheduling, Preparation, Liability, and Claims, which is in its 4th edition, and this 4th edition was published in December 2019, so it's very, very recent. And this book, as we all know, it's a very well-known book. It has a lot of US cases and that deals with scheduling and delay analysis. And in this book, I just want to highlight a few things. And of course, I mentioned this in my submissions, but I'm going to refer to those today because these are in this hearing, because this is very important. The first one, in the second edition in 2003, this was the chapter 8 outline, Dr. Tariq. and the chapter 8 was time impact analysis procedures. As you can see, this is the outline of the chapter. Significantly, in the 4th edition, let's take a look at what's the outline of this chapter 8. You see, there's a new section that was added, and this section is the longest path theory legitimate or not. Now, this is very important because actually this sheds doubt, and it's just showing that according to recent US case law, the longest path theory is now, there's a lot of doubt to its application for applying liquidated damages. And as you can see here, this is the section from the book where it just shows that the authors go into depth discussing the longest path theory and its shortfalls. And I'm not going to get into this in this hearing, but it's sufficient that that this notable shift in the literature is really highlighted in this presentation. Excuse me. Also important to highlight is that the book has this new section, also 9.08, which was not in the previous sections, which if you just look at the title, time due to the contractor for change orders ordered after current contract completion date. So that's the case, Dr. Tariq. Now, is that we had a contract completion date, changes were ordered after that contract completion date. And as you can see here, if you look at this small brief section, it just mentions that when changes are ordered after the completion date, there is the owner or the employer in our case has the potential to abuse his right by subscribing by virtue of the longest path theory. So since there was anything in the midst of this longest path is considered insignificant by those proponents of the longest path theory. So therefore, all the changes that the owner orders are not given attention at all. Whereas in the negative float theory, these changes are negative. They have a negative float, so they are critical as well. However, in this case, we have even here the case of RDP Royal Palm Hotel versus PADC Hospitality Corporation. The owner here continued to issue hundreds of change orders. You can see here after the substantial completion date without setting a new deadline, which is exactly well, of course, in our case, we did not have hundreds of change orders. We had a few, but the owner did not give me any extension of time, did not really acknowledge these variations. And therefore the court, and this is the important, the court concluded that this constituted waiver by the owner. There was a time of the essence provision in the contract, but very importantly, and the right to assess liquidated damages, Dr. Tariq. So actually that just shows where we're heading, where the US is heading, at least.
Excuse me, why are you using the US courts here? The project is in Egypt, as far as I understand. Dr. Tariq,
is this another interruption?
You're wasting your time.
This is another interruption, Dr. Tariq. This is unbelievable.
Gentlemen, you both will know that the hearing is not mandatory in these procedures, neither under the FEDEC procedural rules or the DRBF manual. So this hearing is meant to help all of us to understand the case and to make a third decision on this. If this would continue, I would cancel this hearing and continue giving the decision based on the written submissions. So please help me to continue this session and to both parties to submit their presentation, please.
Sorry.
Okay, I've really concluded my presentation, Dr. Tariq. So I'll give it to the contractor now.
Thank you, Mr. Renner. Thank you very much.
Engineer. Sorry.
This was really helpful. Thank you. Very grateful. Mr. Andil, please provide your presentation.
Okay. Thank you very much, Mr. Chairman, Dr. Tariq. I will start my presentation now. And I have to apologize for the interruptions, but I could not resist, actually, as I said. For my presentation, I have to say that I got inspired by the contractor's presentation, so I had to have myself sitting down and write that the contractor continues his attitude to come up with shiny big statements and elaborate hypotheses on them, while the simple validation reveals very weak basis of argument. Just contrary to the expectations, I will start my presentation that the contractor has a right. I have to admit. My employer issued 3 variations, and these variations are clearly employer's delay, and the contractor is entitled, so I'm just saying this clearly up front in this hearing and presentation. However, the contractor, although he has a right, he's asking for his right in a very, very wrong context, because every right has a subsequent obligation. And in this case, there are a lot of obligations of the contractor to fulfill in order to obtain his right. So I'm going to take the arguments of the contractor one by one and just try to draw his kind of attention to his obligations in order to get it fulfilled later. And then maybe we will come to a conclusion to this kind of dispute. So the first argument the contractor brought is that the longest path completion date is not contractual. Yes, the longest path completion date is not contractual. We have only one contractual completion date, which is the date in the contract. And this date in the contract, which is based upon, is the one you based upon your submitted baseline. So you have a baseline with the contractual completion date, and all the coming or the following updates based on the longest path you submitted through your monthly report are based on the longest path, and they are not contractual. So you didn't bring us, or you didn't reveal a new fact on this one. So you come up with that the longest path completion date is not contractual, and in your context you stated that this kind of theory or this kind of hypothesis are not supported, although you in your same presentation stated that the longest path theory with all the subsequent points under the longest path theory are not recognized, and then you came up and say that they are recognized in the RP. And I'm bringing you here the statement of the RP stating that the longest path and the other theory, which called the negative float and versus the total float theory school, are there in the RP 29.3. Here, the RP 29.3, one of the most recognized references in delay analysis. I'm going to go again to the RP 29.3, comparing between the longest path theory and the negative float theory, and highlighting that the longest path theory is one of the best recognized way to calculate and assess the delay. And in your argument, the longest path theory completion date is not contractual. I have to come up with the same book you quoted from, which is saying that there are some considerations on the longest path theory. Yes, there are some considerations on the longest path theory based on the book you quoted from, and the book you are quoting, I don't know whether you see it. This is the book you are quoting from, construction scheduling, preparation, liabilities and claims. There is some consideration. However, in the same book and the same page you highlighted, the 4th edition, which is construction schedule preparation and claim, 4th edition by Jay McQuire and others. In 8.5, in the same book, the same page you brought stating that there is a problem with the longest path theory and it cannot be used in calculating the delay. In the same book, the same page, the same book is saying that maybe the contract is not referring to the longest path theory as the contractual base of calculation. However, CPM analysis, which we are using in this project, in the contractual schedule methodology, including the contract, the longest path theory, by definition, is the most recognized method in accordance with the AACAI and the SCL, which is the Society of Construction Law, to analyze the delays based on CPM analysis. We have here CPM analysis. You submitted a CPM analysis, and we are following a CPM analysis to assess the delay. You simply presented 3 lines, one stating the commencement date, the other one is stating the time for completion, and a very nice red bar stating that this is the delay. However, in your submission, in my determination, in reply to your submission, there are a lot of analysis showing huge shortfalls and showing that the red bar, the one bar you said, the one bar you stated, the one bar you presented, Mr. Contractor, is 100% attributed to your performance. It's not about COVID. It's not about employer delays. It's not about lack of approvals. It's not about the 3 variation we issued. However, this bar and in your submission, in my analysis, is representing delays attributed to your performance, the rework, the lack of resources, the lack of or the low standards of quality recognized in the all the notice of dissatisfaction NCRs issued to yourself, and the other notices you or correspondences came to you in the correspondences you received during the time of performance. Okay, so I will come to contractor argument number 2. I will come to contractor argument number 2, which is the employer disregard of monthly report qualification. And actually, I inspired this photo. I had to insert in my presentation. I resisted a lot to insert this photo in my presentation. But what the contractor is asking me to consider is something like this. In several correspondences related to your monthly report, your progress updates, the engineer highlighted that whatever you are inserting in the monthly report, and actually I have to highlight that this is one of the major problems we are facing in dealing with contractors in several projects and several other projects, that the contractor is asking or considering that if he submitted a monthly report, if the contractor or if the contractor is submitting a monthly report, and this monthly report consists of progress updates, references, logs, a kind of validation need to be implemented to these updates and these records included in the monthly report. In our case here, what you are trying or asking me to consider in my analysis, in my determination, in my extension of time analysis or delay analysis, the one you submitted, are completely irrelevant. So that's why the engineer regarded what you have submitted, and I'm talking about the Primavera file you have submitted during the monthly report, because I just quoted some comments coming from my submittal to you, or my reply to your submittal of the monthly report, stating that there were some huge or major issues that are fundamentally questioning the CPM calculation in your longest path calculation. So yeah, if we agree, if we just set a hypothesis, then that we agree that you have a right to ask for something, I cannot even use your document to justify this kind of right. I cannot use your document, you know, in all standards, US standards, and we are using here US standards, not because we are following the US law, but we are using US standards related to technical things, not laws, we are talking about common laws in the US. We are talking about common technical things, delay analysis, CPM calculations, extension of time calculations. We are talking about these things. We are not talking about laws here. And if we are going to even take a look at the international standard of calculation or international standard of calculating the delay, we will have that if I can grant you a delay, or if I'm willing to grant you a delay, I have to first to quantify the delay, and then to collect the delay, identify the delay, and then quantify the delay, whether it's retrospective or prospective, and all the retrospective delay we endured in this project are contractor attributed delays. And then I tried to quantify what we have done here, and what the contractor had done here is that he did the first step only, identifying the delays, and he identified only the delays coming from the employer, which the employer already admitted that he issued these variations. But when it comes to highlighting the delays or quantification of delays by mood, which is retrospective or prospective, or coming to the next step to the quantification of such delay, I cannot rely on whatever the contractor included in his submission. So I had to go with my submission. When it comes to the next step, which just some, I will just come back here. I included this, Dr. Tariq. I included in this slide some references to what I communicated with the contractor related to the ambiguities I found in his submissions during the monthly report, during the performance period of the project. So the last argument of the contractor, and which defeated my resistance to interrupt, which is not my normal conduct, is that the employer and engineer did not apply the concept of good faith, or violated the concept of good faith. And actually, when I try to visualize what happened, and I recall the documents and the records and the variations, and I can just simply stand and say, what does that mean? The contractor submitted an opposite variation.
If you allow me, Mr. Kandil, I'm just reminding you of the time limit you have. So I think you have 3 minutes to go. So please.
Yeah, I don't need more than 3 minutes.
Okay, please.
I don't need more than 3 minutes. So when it comes to the good faith and the variation the contractor submitted a variation stating that there is a variation. Okay, you asked me for a variation, Mr. And I admitted, the employer, me myself as an employer representative, I admitted that I issued a variation to the contractor. But the contractor obligation, which I highlighted at the beginning of my presentation, the contractor obligation is to quantify the impact of this variation, because he is the technical owner of the site and the site activities. He didn't do this. The contractor need to highlight the impacted activities and how this variation will impact the critical path, and initially give the indicative impact of this variation. The contractor didn't do this. And the contractor is requested to apply whatever mitigation he has to normalize the impact of this variation I asked and I admitted, so that I can grant him, or say, okay, Mr. Contractor, I'm not going to take this variation. So the contractor has not done any of his obligation, so that I can grant or just disregard asking for this variation. When it comes to me, and when it comes to my employer, and just put all the papers on the table and try to visualize and take a decision, we find that the project is delayed for nearly 1.5 years, and this 1.5 years is totally attributed to the contractor, and the contractor is not showing any seriousness to recover or to complete this project, even if we are asking for variation. Maybe in our let's say evaluation, that these variations are not that major to stop. I think it's part of our right to follow the contract and apply the liquidated damages. For me now, I'm done. I highlighted here that a simple quote from the same book stating that the longest path theory, yes, it is criticized, but the longest path theory is recognized in the book and the other standards. And I put the definition of the longest path theory here just for reference, for the dispute resolution board reference. And thank you very much, Dr. Tariq, for listening to me. And that's all for the contractor, for the engineer part.
Thank you, Mr. Andil. This was very helpful, very grateful. So I'll start with addressing some questions to both parties. Please bear with me. The first question is addressed to the contractor. If the use of longest path theory is not correct, is it correct in your opinion that the contractor's delay are wiped away by application of the negative flow theory?
Well, actually, Dr. Tariq, the short answer to your question is no, I don't think so. And actually, I have to restate what I mentioned in the beginning of my presentation. When I mentioned the red bar that the contractor, that the engineers mentioned in his presentation, it seems the engineer has misunderstood. The red bar, I completely acknowledge that it is the contractor's delays. As I mentioned, I had problems with resources. I had cash flow problems because of COVID-19. I acknowledge that. However, but I do not, of course, believe that the contractor's delays should be wiped away. But however, we should have mercy on the contractor because, you know, the employer cannot just issue variations and not even consider those variations to have any impact because of a fictitious date, forecast date, and a longest path that corresponds to a date that we didn't even agree on in the contract. So if there are variations that have been issued, and these variations have to be taken into account when assessing liquidated damages, we have to take into account that we have a contractual completion date and there were no extensions to this date, and that applying liquidated damages is on the contractual completion date, and the engineer has an obligation to extend the contract completion date before the engineer can apply liquidated damages. So that's my answer, Dr. Tariq, to your question.
Okay, I can understand this. Thank you. This is very helpful. Thank you, Mr. Contractor. So the question now to the employer. The engineer mentioned in the last slide that a contractor who is driving the longest path to completion does not get any relief from damages. Now, what about the variations that have been ordered after the completion date? Would these entitle the contractor to a time extension and relief from damages?
My short answer is no. Nothing is relieving the contractor from the damages. Maybe Hussam can elaborate more.
Yes, what I can say here is I totally agree with my employer. However, everything needs to, in accordance with the longest path theory, or what is longest path is all about, is to do analysis, to create a model and come up with multiple float paths, multiple critical paths that can be attributed to each performing party on site, and then come up with either one attribution of the delay to a single party or a concurrent delay. This is a huge calculation that cannot be just represented by a couple of bars. This is just a model and analyzing the model and just trying to understand whether it's a retrospective mood or a prospective mood. So it's a huge calculation. However, but the bottom line, the bottom line is that no, I agree with my employer. It's not relieving the contractor from the liquidated damages.
Thank you, Mr. Afifi. Thank you, Mr. Andil. This was helpful. Thank you, gentlemen. Thank you for attending this hearing session. I believe now we conclude this session. Shortly, you will receive a procedural order from my side stating dates for submitting closing statement and stating the date to render the DAAB decision shortly after this hearing. So thank you, everybody. Thank you for your cooperation. and hope this dispute would be solved in the right way. Thank you.
Most welcome.
Thank you, Dr. Tariq.
Thank you.
Dr. Walid,
okay, everyone. Thank you thank you for. This concludes the presentation. Now we're going to go to the questions and answers. Shmans Ahmed, if you can kindly take the question.
I will take the question one by one, but please, whoever will take the answer, make it as short as you can, because we have only 20 minutes, and so far we have 4 questions. So the first question from Mr. Haitham, both parties are arguing based on the US courts sources and cases. Isn't there any guidance from the Egyptian courts? So in short, is there any Egyptian cases which is supporting the case? Dr. Ali, can you take this, please?
Yes, sure. Actually, this is a good point. It's true. We argued, actually, as Hussam mentioned, he clarified in his presentation, we're taking it from a technical sort of standpoint, because simply in Egyptian law, they don't go into something as intricate as the longest path negative flow theory, or the as collapsed as built schedule, or the TIA. But of course, in this presentation, I touched on the issue of good faith. Actually, this is something that would be a very potential good, a research topic, is how delay analysis concepts that an Egyptian civil code or Egyptian law references. Hussam, did you want to mention something? I think you.
Yeah, I wanted to refer to what I mentioned in the presentation, in the context. Actually, I saw this questions. I saw this question. Sorry, during my presentation, and I intentionally mentioned that yes, maybe for the law, you are more than capable to answer the question, but we are referring to global standards for forensic analysis and delay analysis, and actually these standards are an elaboration of a lot of practical experience and huge experts and very experienced people who contributed deeply into every single details and came up with what we have now. And actually they continue elaborating and developing and recovering the defects in these standards worldwide. So I believe these are not America in the part of the forensic and delay analysis and scheduling part of the analysis and calculating the concurrency. I believe there is nothing called Egyptian standards or US standards or US source or Egyptian source. This is one international code that can be applied anyway, as long as you have a proper schedule and a proper project completion.
So taking the second question from Mr. Muhammad, appreciate to state that if there was agreed delay analysis method in the contract, in case not, then what is delay analysis method used by the contractor and the employer? So I guess there is Hussam. Can you take this?
So I don't fully understand the question. Thanks for this.
Is there any reference in the contract or guidance to use the delay analysis method?
No. We are trying. There is a research effort now to come up with a kind of scoring sheet to recommend
about the case, yeah, Hussam. In this case.
Yeah.
In this case,
if I may, in this case, if I may, برضو هي تفضل حسام تفضل.
لا خلاص مش مشكلة. أنا بس in this case the information in this case the information is very general, so that we cannot just go and recommend a method over a method. So in the case we are presenting here, it's just generic. We can apply any method. There is no specific delay analysis method that can be applied. However, in general, I was answering. Even in any contract, there is nothing delayed. The content and the available information are the one binding or driving to a certain methodology. So this is what I was trying to say.
Dr.
Yeah,
Walid,
I wanted to just say that we intentionally removed this. We did not mention this. What delay analysis method was used, if it was mentioned in the contract or not, because actually that's a bit immaterial to the cases. As Hassan mentioned, the concept of longest path theory versus negative float, that's not really related to what time impact method that is used. These concepts and that debate has to do with actually the definition of what is a critical path. So how do you define a critical path? Is it just simply the longest chain of activities, or is it the longest chain of activities leading to the contract completion date, and after that contract completion date, it's negative, it's all negative float. And of course, it's a bit relative. There might be a float, a path that is more negative than the other, but they're both negative. On the other hand, the longest path theory, there's only one longest chain of activities leading, and everything else is not critical. So that's really the essence, the definition of the critical path.
So
I agree, Oli.
So second one from Mr. Akram, but it's not a question. Actually, it is a comment, and actually it's explain what about the case, what the case is about. So yes, I agree with you, Mr. Akram. Ms. Nurhan, do the employer give the contractor time extension and extra money to the contractor attached with variation? Do the employer gives the contractor time extension? You talk about the course of the contract, or in this case.
Yeah, I think she's saying that the employer give the contractor time. You see, Bashmandisa Nuran, the thing is there's a difference between a CVI and a CVO. The CVI is just an instruction to proceed with the variation, and that's what happened with those 3 variations that were issued after the completion date. A CVO is actually what you're referring to, has the agreed time and the cost. So in our scenario, the employer through the engineer just instructed the variations, do this variation, and of course contractually, if there's an instruction for a variation that is issued, the engineer cannot really say I'm not going to do it unless there are compelling reasons not to do it. So that's why in those CVIs that were issued after the completion date.
Next question, Mr. Haitham Saad. To the engineer, does the contractor failing to provide variation impact for cost and time means he has no right for extension of time? دكتور طارق، عايزين نسمع صوت حضرتك في السؤال ده. It's a good question.
ومؤلم كمان.
This is addressed to the engineer.
معلش يا دكتور، معلش ده كلام الأسئلة، بس عايزك تجاوب على السؤال. اتفضل دكتور.
Does the contractor failing to provide variation impact for cost and time means he has no right? We have to define how this failure was it a failure to submit a notice, or is it a failure to submit details and particulars for the effect of the variation?
السؤال بيقول البارتيكولرز بس fail to provide impact. فهو بيتكلم ان هو ما قدمش الكوست بتاعه.
Yes, if it's only يعني لو impact بس these details and particulars, he will not lose his right, of course, but he may lose some evidence and some contemporary records that can validate his claim. So this is the main problem here. It's not a question of entitlement. It's a question of evidence here.
I have just a simple.
اتفضل حسام.
لا خلاص يا وليد، اتفضل انت.
Go ahead.
لا معلش اتفضل.
لا اتفضل. Go ahead.
طيب I have a simple input بس هو.
I was just gonna say that.
طب معلش، لا خلاص يا وليد، انا هسكت، كمل وانا هخش، انا هقفل انا الكونفرنس. اتفضل.
لا. طيب okay. I was just gonna say that يعني I've recently spoken about this, is that when we talk about, for example, time at large in a UK context, one of the factors that can set time at large is actually this engineer's failure to provide a determination on any variation, or so even if a contractor fails to submit or provide backup, that does not mean that the engineer has a get out of jail free card and will say, it's rejected. No, that if there's a variation, then there's a reasonable time that it should be completed in. And if the contractor fails in providing documentation that the contractor has taken the risk of the engineer, say if the contractor wants 100 days, the engineer can say you're entitled to 5, but he's entitled to something. I mean, that engineer's failure to do that can actually set time at large in a UK context, for example. And there's similar to time at large, we have also similar things in Egypt as well. But that's my answer to Mr. Haytham's question is a definite no. If the contractor has a right for time and cost, even if the engineer, if the contractor fails to submit substantiation. Over to you, Hussam.
Okay. I totally agree with you, Walid. It's a definite no. And it's a very good question, a very powerful question, because sometimes we employers and PMCs, I used to be a contractor, to look very vicious when we come up to this point, saying that we are not giving him an extension because he failed. I tried to be vicious, but I'm kind by nature during the presentation. So the point is, I think, Haytham, no, if we are in a good faith environment, and actually, I remember one of our projects before the contractor had a variation during this project, was in Morocco, and the contractor had a variation, and actually we all acknowledge that there is a variation, and a very serious variation in this project, and the contractor had some kind of lack of documentation, lack of personnel who can do such analysis. In this case, the engineer himself helped the contractor to come up with a kind of determination. So it's not about just putting someone in a corner and say that you don't have a right because you failed to provide a substantiation or a documentation related to your variation. If it's a variation and it's a clear variation, and the contractor, and everybody knows that the contractor has a right to issue this variation, and if it's a matter of kind of logistic issues or not laziness, by the way, not laziness or procrastination issues by the contractor, and it can be recognized, by the way. If it is not related to these kind of context, I believe every party in the project should support the contractor come up with a fair evaluation and fair claim to preserve his right and prevent any damages that could get to the contractor.
Thank you, Hussam. Taking the next question from Mr. Tamer: does an extension of time submitted by the contractor and under the study by the engineer and the employer give the contractor the rights to be exempted temporarily for applying liquidated damages on him until the EOT is decided upon? I can say the short answer is
yes.
I guess yes. بس be harmful. بس دكتور وليد عايز تضيف حاجة للإجابة؟ دكتور وليد حضرتك عايز تضيف إجابة على السؤال ده؟
EOT submitted by the contractor. I'm reading the question. Does an EOT submitted by the contractor
Actually, from my standpoint, I can say yes, but it depends.
I don't believe it gives the right to be exempted from liquidated damages, but let's not forget that this is a part that we actually, this is a very important part in the presentation. The employer has an obligation to notify the contractor when damages are going to be applied. So if we're going to go with a FIDIC contract, and bear in mind that in this presentation, and this is a very important point, is that there's a time bar on the employer when presenting claims, and this time bar also applies to applying liquidated damages. So if the employer intends to apply liquidated damages, then in our scenario, at the contract completion date, the contractor should have received a notice saying I will apply liquidated damages.
هو في extension of time is under determination. بس لسه ما فيش date of
Ahmed, can you please اتكلم English عشان بس في بس other English speakers.
The question is saying that there is no completion date for the project because there is an extension of time claim have been submitted. So actually there is meetings and consultation meetings for the extension of time determination. So he mentioned temporarily, can we exempt applying the delay damages temporarily until we have the extension of time determination? Only on temporary basis.
Hello?
Dr. Walid, حضرتك سمعتني? Did you hear me?
Yes, I'm saying سمعتك بس network is not that good. بس أنا برضو I again mentioned that there is no exemption given to the contractor to apply liquidated damages per the contract. But if the employer decides to exempt the contractor, in that case, they should be notified. And actually, the contractor must, the employer must مثلا say, I will defer the liquidated damages, for example, until I review your claim, for example.
I think this is the question.
We've done this.
Yes. Okay. Next question. Ms. Fatma Hussein, will there be another webinar to know the dispute board decision? لا ده طمع يا دكتور باشا لسه فاطمه. This is the I don't think you may talk to Dr.
I believe
Tariq
he will give us the determination now.
I guess so. Dr. Tariq may have the answer now. So
No, I don't.
I don't think Ms. Fatma. I don't think. Mr. Omar Abdul Maqsood, what are the theories of or course of action given by DAAB members to control the hearings? Dr. Tariq.
No specific authorities or course of actions. However, it's based on the rules set at the beginning, based on the personality of the DAAB member himself, based on the overall setup of the written submissions. So if he believes that the session, the hearing session is not productive, is not fruitful, is full of interruptions, so he has the authority to cancel the session simply.
Okay. Due to the time shortage, we will have only one more question. Will the engineer be Mr. Muhammad Ahmed? Will the engineer be held responsible to justify his determination when the contractor refused to justify his submitted CVI's time and cost impacts? It's a really heavy question. held liable or responsible against مين برضو بس دكتور وليد.
Yeah, I contractually no. Contractually there is no obligation for the engineer. For example, one of the common things that I encounter is, for example, the contractor submits a time extension using impacted as planned method, for example, and the engineer just says no, you're not entitled to this amount of time. So the contractor's first response to show me how did you get this your determination. Show me your analysis. The thing is, there's nothing in the contract, the physical contract, that actually forces the engineer to provide his substantiation. Although, of course, it has to be well reasoned. Well reasoned does not mean it can't be just كده something out of the blue. But there is no tit for tat or obligation to provide this substantiation. But it has to be, of course, well reasoned. It cannot be just any random rejection.
Dr. Eid, I think by saying this was the last question due to the time. So you have the floor.
Okay. I just want to thank everyone for attending, all the practitioners in the industry, and I also want to thank. I see a lot of students. I'm very grateful that you attended and you've witnessed this debatable topic in the industry. And again, remember, if you can join the AACE or the DRBF, and so that we can bolster the Egyptian contribution to these two organizations, that would be great. So again, thank you so much for your attendance and for your participation.
Okay, for my part, thank you everyone. Wish to see you again soon.
Thank you everyone for your time. Dr. Tariq.
Yes, Doctor.
Thank
you.
Thank you.
Thank you.
Thank you very much. A pleasure to have you all here. Thank you. Have a good night.
Take care.
Bye.
Assalam.